So you might wonder, what is a medieval Islamic law guy doing at a conference on Rhode Island? And I've been asking myself that question since I got here. Just to give you a little bit of background, to me, I wear two hats. I'm trained as a medieval legal historian of Islamic law. Actually, my former mentor is sitting right there, and that was many years ago. But I'm also trained as a lawyer. So as I move back and forth between the past and the present, in terms of law, I also move back and forth between the Islamic and the contemporary democratic constitutional. And a lot of the work I do then is situated in this weird in-between place. I'm neither here nor there. I'm neither present or past. I'm somewhere in some weird liminal space. And as anxiety-producing as that can be, I actually find it very generative. I find it a generative space for me to think about law and to think about the relationship between legal traditions now coming into contact. And just to give you a sense, when I arrived in Toronto in 2005, I came to this controversy, the Sharia debate. Should Muslims in Ontario be able to arbitrate family matter disputes using arbitration outside of the courtroom? And the government said no. There will be no religious law in Ontario, one law for all Ontarians. A year or two later, then Archbishop Rowan Williams made a very famous speech in front of a bunch of lawyers and law professionals about creating space within the British legal system for Muslims to arbitrate family law matters. And then there were calls for him to resign, and the Queen had to was a bit miffed, I think, at him for a bit. And I have been engaged then, both in the academy and outside, in thinking about what exactly do we understand Islamic law to be. In the United States, of course, we have an ongoing debate here. One of the things that's around these anti-Sharia bills, one of the things that has animated my research into the Islamic tradition is some of the fears and the source of the fears that animate the political outcry, and that is the issue of tolerance. Is Islam and Muslims who would adhere to it, are they tolerant of the religious other? That's really what it comes down to. Can they abide by otherness, whether it's Jewish or Christian or others? And if not, well then what should we do with our Muslim neighbor? What should we do with those who want to espouse some sort of notion of Sharia in their lives? And you certainly see a lot of literature which then tries to answer this question by looking at what I call I reference it in the title of the talk, the dhimmi rules. Now, who's the dhimmi? In pre-modern Islamic law, the dhimmi was the non-Muslim permanent resident in Islamic lands. Islamically governed lands, as they conquered, they then incorporated other minorities, whether it's Zoroastrians, Jews, Christians, or whatnot. Just imagine the early expansive period from the Arabian Peninsula out to Spain on the one hand, out to India on the other. And you can imagine the ongoing incorporation of religious minorities. And my jurists had to decide, what do we do with these folks? How do we manage them? Because on the one hand, there is the imperatives of conquest. There's legitimation of conquest with a universal message of Islam and spreading it, whatever that might mean. And there's the fact of diversity, religious diversity. You can kill them all if you want, but then who's going to work the lands? Who's going to pay taxes? How do you support the engines of empire? But if you let them stay and remain in place, well, then you have a problem in trying to uphold the public policy interests of whatever it means to have an Islamic public ethos. Hopefully by now this should be resonating with many of you. If you're thinking about Park 51, the Ground Zero Mosque, if you're from Tennessee and are thinking of Murfreesboro Mosque, if you're thinking about these Sharia bills, this should sound familiar. Why is it that Oklahoma passes an amendment to ban international law and Sharia? Well, on a democratic theory, how can we implement law that hasn't gone through a democratic process internally? International law is foreign law, and Islamic law is just a worse version of it. So the idea then is we are at all times trying to construct through the law this conception of the public, this conception of our ethos, whatever that might be. And certainly you can see in these bills that concern, and where again the dhimmi rules come from is, if you look at these bills, where they're coming from is one particular person, David Yerushalmi, who happened to have been an author for a report for the Center for Security Policy issued a report in 2010 on Sharia, the next threat to America. And he was a co-author. And part of the logic of their argument about Sharia being the next threat is Muslims are intolerant. Any Muslim who abides by Sharia cannot ignore these dhimmi rules. And if you take the dhimmi rules seriously, and a Muslim takes Islamic law seriously, then they are a threat, and we need to regulate Sharia. So the bans on Sharia come out of this fear. And so we're all here talking about the different projects we're working on. My book was on the dhimmi rules, and I wanted to target this. And part of what the argument that I make is that tolerance is the wrong frame. To argue about the dhimmi rules using the lens of tolerance misses the larger purpose of these rules. The rules are discriminatory on their face, some of them, but the rules are also accommodative on their face. So tolerance and intolerance overdetermines the significance of these rules. What the rules do is they do what all the rules do that deal with minorities. They're symptomatic of the messy business of governing in a diverse polity. So just to give you an example, Islamic law bans the consumption of alcohol. But if you're a dhimmi living in the Muslim polity, you get an exemption from that rule. So you could think, well, that's an accommodative spirit, sure. However, the ban informs a public policy against alcohol in the public sphere, and so it creates a corollary rule on banning public drunkenness. So the dhimmi can consume alcohol, just not be public about it. Suddenly there's a concern about the public square, whatever that might mean, right? They don't define it, but it's there. Likewise, on charitable endowments, can a Jew or a Christian endow what was called a waqf, a Bible or Torah reading school? Well, it depended. One group of jurists said, sure, if it's legal in their tradition, absolutely. Another group of jurists said, well, it all depends on their tax liability structure, right? So connecting it back to governance. But a third said, well, if we allow the Sharia to permit dhimmis, Jews and Christians, to create a Torah reading school, we're perpetuating disbelief in the land. And he makes an analog to saying, well, wouldn't that be like allowing this doctrine to support non-Muslims to create an endowment to support and arm our enemies outside the Muslim empire? Suddenly, charitable endowments become the site of security and existential concerns about the state. So what I simply want to suggest is that these rules, although they form and contribute to a larger climate of fear around the tolerant or intolerant Muslim, actually are not all that different. And that's probably the most provocative part of the book, is that after having addressed the dhimmi rules, what I argue then thereafter is, don't we do this all the time? And so I looked at 3 cases, one from the Conseil d'État in France, one from the United States in Florida, and a third from the United Kingdom, all of which regulated the covered Muslim woman. Covered Muslim woman appeared before the government in France seeking to become a citizen of France. The government commissioner opposed it, citing the fact that she wears niqab, citing the fact that she doesn't go out much, citing the fact that when she shops, she only goes out with her husband and doesn't really like to leave his presence unless it's with other men in the family. The government argued, and the court agreed, that she has not adopted core French principles, specifically gender equality, without defining any of those. So in a sense, she's an unbeliever, like my dhimmi. And as an unbeliever, she's not a full member of the polity. She speaks French, she has her children here, she pays taxes, but we're not going to let her be a citizen of the state. That's one. The second was the Freeman case, Freeman versus Department of Motor Vehicles in Florida, a case in which a Muslim woman wearing the niqab, the face veil that reveals the eyes, had a driver's license in which she wore the face veil. 4 months after 9/11, she gets a notice saying you need to come back and take a new photo that's a full face photo, and she opposes on religious freedom grounds. The court argues that her conception of religion is not in fact substantively burdened at all. That using and relying on what we were talking about last night with the keynote, the Religious Freedom and Restoration Act, is, look, we don't disagree that she sincerely believes this, but really, is this a core value at all? What they argued is, well, other countries allow women to remove the veils for passport photos, and of course, they don't identify what those other countries are. But what's interesting is, let's take those other countries like Saudi Arabia and Iran. Yes, they do require women to remove the veil after having the general rule of actually requiring them to don it in the first place. So there's an anti-democratic element here where not only is this American citizen who's not a member of the Saudi or Iranian polity is nonetheless held to a construal of her tradition that the court construes by reference to something she doesn't actually participate in and has no voice in. So in many ways, she is then othered as an American citizen, is holding to a tradition not domestically construed, but nonetheless not even construed by her. And my Muslim jurists would do the same thing in holding Jews and Christians liable to their law, but on terms that were familiar to the Islamic legal tradition of what counts as law. Right? So this is, again, an example of how courts construe religion quite badly. The third example having to do with Shabina Begum in the UK, a high school girl wanting to wear the jilbab in contravention of the school's dress requirements, uniform requirements. The court, the House of Lords, in this variety of speeches, this is before the Supreme Court was instituted and the House of Lords dissolved, at least the law lords element. What was really fascinating about this case was how security mattered. Every single law lord in the House of Lords decision talked about how we must support the uniform requirement and restrict her religious freedom out of concern for third-party rights. Third-party rights meaning the other girls in the school who might feel pressured. There's no evidence in the court except a few anecdotal statements from some teenage girls who were really upset about the idea of that. And every single member of that court referred to extremist Muslims who protested outside the school, telling Muslim parents not to send their kids to the secular school. Every single speech referred to that extremist protest, and every single one that said, but it's completely irrelevant to the proceedings at hand. Well, if it's completely irrelevant to the proceedings at hand, why mention it? Because it actually forms the context that inform the third-party rights considerations. And so what I want to suggest is that just as my Islamic jurists are worried about security, worried about how to construe the traditions of the other, so too do we. When we talk about courts doing religion badly, all courts have done religion badly, particularly religion of the other. So where does that leave us? Well, that leaves us with the argument that, at least in thinking about religion and tolerance, religion and law, or tolerance and law, again, I want to suggest that law becomes a mechanism for doing a lot more than just simply protecting the other. It becomes a side of a lot more going on than just simply religious freedom in these cases. There's economics, there's security, and as much as Brian Leiter talked about the Millian argument of harm prevention, he also acknowledged the Hobbesian element of, at a certain point, we have to make prudential considerations that justify limitations on freedom. What I worry about is that in moving from the Hobbesian prudential argument, we move to the Schmittian sovereign exception argument, which effectively what we're doing is we're allowing the state through these mechanisms of law to justify limitations, but the limitations are justified so shoddily as to reveal to me the larger ethos of the state coming and looming large in these pictures. So where does that leave us? Well, the actual paper I actually forwarded to Dan builds on this research because, as you can imagine, Sharia has been an issue in the Middle East and North Africa. As the Arab Spring has taken shape, as the Muslim Brotherhood took power, was removed from power, or was a coup, whatever your politics are, either there was or there wasn't a coup, and I'm not going to get into that. If you're thinking about Ennahda in Tunisia, my own work was in the Maldives, where you have Islamic law, civil law, and common law all mixed together. The question is, well, what is the place of Sharia in these contexts? And a lot of advocates suggest that you need to, on a separation thesis, remove Sharia out of the picture. What I want to suggest, though, in a way that reflects the work I've already done and shared with you, is that the larger sovereign context within which these laws take shape draw upon what hermeneuticists would call the always already, or what someone like Charles Taylor from Canada would call a social imaginary. And I want to suggest that Sharia actually is part and parcel of the social imaginary. To rip out Sharia from the context is to remove a set of core content from how people understand their place in the world. If you were to do that, I think that actually not only is it anti-democratic, I don't think it actually understands. It's a misunderstanding of the way Sharia constitutes resources in these regions. The real issue for me isn't whether Sharia is or isn't in these contexts. The real issue is how do you negotiate the fact that Sharia sits side by side in these contexts with other legal traditions that are equally at play. So it's not an issue of tolerance as a matter of law, it's about negotiating the sovereignty of different legal traditions as they coexist. It's a legal pluralism problem. In the United States, we manage legal pluralism rather okay, I would say, through federalist ideas, through the notion of federalism, and we grant jurisdictions to the state, to the federal government, and we try to respect the sovereignty of states. But what I want to suggest is when you have a unitary state with multiple legal traditions that act at any given time with multilateral treaties, conventions, and human rights commitments, the story gets very messy. I don't think it's a story that can simply be resolved by removing Sharia out of the picture, but it's a story going forward that has to reflect on what is the space for legal pluralism. And I don't think this is just a story about the Islamic world. I think it's a story about America too. What is the space for legal pluralism such that Muslims can or cannot, may or may not want to, adjudicate certain issues related to their personal matters pursuant to Islamic norms? We create space through arbitration to do so. So whether you're in Britain, whether you're in Canada, whether you're here, we allow, as a matter of our legal system, parties to negotiate, parties to contract, and parties to arbitrate these disputes outside of court. And the moment we say, not this law, but that law, we are making a decision against legal pluralism. And what I simply want to suggest and put on the table is that instead of really thinking about tolerance, I want to put on the table the larger question of legal pluralism, whether it's in the context of Israel, where you have the secular tradition and the basic law and halakha, which is really messy. I like mess, but it's also really troubling, particularly for the women in the Wall case. So just to connect it to our two papers. So with that, I'm going to conclude, but thank you very much.
Thank you very much.